Can a contractor sue without a written contract? This question often arises in the construction industry, where verbal agreements are common. While having a written contract is always the best practice, there are situations where contractors may have legal recourse, even without formal documentation. Contractors have several potential legal options when seeking payment for work completed without a written contract. These include filing liens, pursuing quantum merit claims, and in some cases, filing lawsuits based on implied contracts. Lien rights are a powerful tool for contractors, but their availability varies by state. Some states require a written contract for a contractor to file a lien, while others are more flexible. For example, certain states allow liens based on oral agreements or partially completed work. Contractors should always check their local laws before assuming they can file a lien without a written contract. In some states, the economic loss rule can prevent lawsuits when damages are purely financial. This rule is particularly relevant in the construction industry, where contractors might experience financial losses due to flaws in design documents. Maryland, for instance, upholds this rule, limiting contractors' ability to sue designers for negligence without a contract. Quantum meruit claims offer another avenue for contractors to recover payment. This legal principle, meaning as much as he deserves, allows contractors to claim compensation for work performed, even without a formal agreement. To succeed with a quantum merit claim, contractors must prove that work was completed and the client benefited from it. Courts may also recognize implied contracts in certain situations. These can be implied in fact, based on the actions of the parties, or implied in law, also known as quasi-contracts. For example, if a contractor begins work with a client's implicit approval, a court might rule that an implied contract exists requiring the client to pay for services rendered. When considering legal action without a written contract, contractors should gather all available evidence of the agreement and work performed. This can include receipts, emails, text messages, or witness testimonies. It is also crucial to be aware of state-specific statutes of limitations for oral contracts, which are often shorter than those for written agreements. Small claims court may be an option for contractors pursuing unpaid work under an oral contract, especially for smaller amounts. However, the best practice for both contractors and clients is always to have a clear written agreement in place. This protects both parties and can prevent costly and time-consuming legal disputes. In conclusion, while it is possible for contractors to sue without a written contract, in some circumstances, doing so can be challenging and risky. Understanding the legal options available, such as lien rights, quantum merit claims, and implied contracts, is crucial. However, the surest way to protect your interests as a contractor is to always insist on a written contract before beginning any work.